Welcome to the HR Legal Lowdown, where we take a moment out of our day to talk to you about hot topics in employment law. Today I'm joined by David Straight, partner at HR Legal. Welcome, David.
Thank you.
Today we are unpacking a recent decision, the Fair Work Ombudsman and Woolworths. It's all about set-off clauses, which is a bit of a tricky area in employment law. All right, David, you're a lawyer, so let's start with the definition. What exactly is a set-off clause?
A set-off clause is a contractual clause that allows an employer to redistribute an overpayment against an underpayment. So if an employee has been overpaid for a period of time and they've been underpaid for a period of time, the employer can take that overpayment and use it to pay off the underpayment.
So a circumstance might arise in a workplace where someone has been overpaid for a long period of time and therefore the overpayment can then be set off against the underpayment that followed.
It's not quite an overpayment in the way it sounds. It's an overpayment, or it's a payment under their contract, which is higher than their minimum entitlements, usually under the award or an enterprise agreement. So it's not as though the employee is looking at their salary every week and going, wow, I'm being overpaid. My contract says I get paid, $100,000 a year and I'm getting $120,000 a year. What their contract says is they're getting paid $100,000 a year, but the background accounting might be under the modern award or under the enterprise agreement, they're only entitled to $80,000 a year. And
right.
The employer, therefore, let's assume it's $80,000 under the award, $100,000 under the salary. Mm-hmm. The set-off clause says that extra $20,000 can be used to offset any underpayment that might arise.
Right.
So where might an underpayment arise? Well, an underpayment might arise because in one particular week, an employee might do 10 hours of overtime and then come in and decide to work on a Sunday.
Right.
And all of a sudden, if you factor what their salary, their minimum entitlements to under the award are, it's higher than what their weekly salary is.
Yeah. And this is why it was such a big case that's recently been through the court.
Huge case. This will cost employers billions of dollars trying to rectify underpayments that weren't previously recognised as underpayments, because previously employers understood that they could essentially reconcile these overpayments against underpayments, perhaps throughout a year or 6 months or a fortnight, whatever it may be. The decision has now said that you can only do it in each pay period. So
right.
Each pay period, an employee must receive at least the minimum award arrangements or entitlements.
David, what was wrong with the pooling method that organisations had used?
So before this decision, there was nothing wrong with the pooling method that organisations had used. That's great. But this decision ultimately said that you couldn't pool wages across pay periods. So again, the critical consideration is that in each pay period, an employee must receive their minimum award entitlements, and you can't reach into or go into another pay period to offset that. So before you could, and a lot of employers do, you might have monthly periods where the salary arrangement is reconciled, but if the pay periods are weekly, you couldn't rely on those monthly reconciliations. You have to go back to, is the employee paid the minimum amount per pay period?
I know that this doesn't cross into your area of employment law, but this looks like a lot more administrative work across payroll departments across the nation.
It's a good point, because the primary part of the decision certainly concerned offset clause. The second part of the decision concerned record keeping.
Okay.
And what the decision said was that in order to comply with the Fair Work regulations, every time an employer or an employee accrues a penalty rate, whether it's overtime, late night penalty rates, it might be shift work through the night, the employer has to have a record of that penalty rate being accrued.
Right.
So where employee or employers might say, well, I've got Alex on a salary, so she doesn't accrue any penalty rates, the courts have now said, no, Alex might accrue overtime. You need a record of that.
I think I really appreciate your explanation of this, because it's really starting to fall in place for me, and I can immediately recognise the pitfalls that employers will come across. But could you talk us through some practical steps that what organisations can do to avoid running afoul of these changes?
Yeah, so there are a lot of challenges. one of the critical practical steps is to understand what awards apply to your employees and understanding what their minimum entitlements are. Then at the outset, you can figure out whether your salaries are high enough to absorb those minimum entitlements. It's critical to look at as well whether you're keeping records, whether you're recording when employees are performing overtime, when they're performing work that incurs a penalty rate, such as weekend or late nights. You probably need to start thinking about how that works with employees working from home and working flexible work arrangements. Really challenging if you've got employees turning their computers on late at night to do a little bit of extra work. But these are the things employers need to think about.
So instead of applying blanket rules across pay cycles, it's more important to get these things right, and the detail needs to be at a high level.
The detail, I mean, when you're talking about salaries and wages, every dollar counts,
Of course,
ironically.
of course.
So once you know what your employees' minimum entitlements are, you then need to start doing a reconciliation to realise or figure out if your wages are high enough to cover those minimum entitlements. And if they're not, you're going to have an exposure there to an underpayment of wages claim, which no employer wants.
No employer wants that.
No.
Now, David actually delivered a wonderful webinar recently on this very case and this very topic. So if that's of interest for you, I encourage you to get in touch with me, myself, Alex. I am the Community Engagement Manager at HR Legal. So if you'd like to see more about this topic and David Straight, our wonderful partner, we'd like to hear from you. Thank you.